People v. Brown.
Good afternoon, Your Honors. Harold Ferguson for Appellant Jason Brown. We'd ask for 2 minutes in rebuttal in this case.
Yes.
If the People's Standard were granted in this case, it would essentially vitiate this court's holding in Hinshaw and would create an odd situation where if a car is impounded for public safety and has to be independent of criminality, but a traffic stop doesn't have to be independent.
So is your argument that there is a public safety exception to the Fourth Amendment and it wasn't applied correctly here, or there isn't one?
It would be naive for us to say that there is no public safety exception for the people, for the police to stop a car. Even though this court has not specifically said that there is such a thing, I think it would be beyond the pale for us to make a suggestion that in no circumstance could the police stop a car for a public safety.
So then what's the standard? Doesn't the board say all of these stops based on reasonableness?
It's several things. There has to be specific, articulable. If you look at what this Pennsylvania Supreme Court did in Livingston, it is specific.
Well, let's look at what we'd say first.
Okay. Specific, articulable facts that it should be independent of any suspicion of criminality, and that the stop has to be
well, I'm sorry, we've said that somewhere.
Right, and the stop has to.
Yeah, but where have we said that?
Right.
What case law? Where have we said that?
You have not.
Okay.
You have not.
I'm asking you for what we've said. I'm sorry. I'm not being clear. My apologies.
This court has not addressed the issue. This is the first time that it's
So
come
why isn't this really a claim of an exigency, based on what the officer said was the motivation for the stop? The observations and what the officer was concerned about. Why isn't that really just an emergency, an attempt at an emergency exception?
It's still within the community caretaking exception. It's one of the three possibilities is exigency. But here, he does not indicate that he is simply stopping this car under an exigency. He's also saying that he's stopping it because he thought something illegal was going on, which meant that he needed reasonable suspicion.
But the Pennsylvania test in Livingston, they don't carve out it has to be a pure motive, for being a community stop, right? They say it can be mixed.
It can. That's what the Pennsylvania Supreme Court says, but I think it needs to be.
So it would be a subjective. This particular officer didn't have any criminal investigative intent.
I'm not sure which.
So if the officer subjectively is saying, okay, this looks like maybe the person's having some issue, a health issue, but it could be a kidnapping. That's not good because in the back of the officer's mind, they have this idea that it could be criminal. So that's not community caretaking function.
I don't believe it's a community caretaking function under the facts of this particular case.
No, but just generally, if we're going to apply this test going forward, if we come up with a test.
There could be a situation where that is possible, but then it would really be the reasonable suspicion that the police officer was stopping this car.
So, again, not a community caretaker situation.
No, that would be, if you thought that there was reasonable suspicion of a kidnapping, of course you would be able to stop the car.
No, understood. But this is below reasonable suspicion. So here's how I was thinking about this case. You have a police officer and they're walking in a neighborhood and they see a door swing open on a house and they think, it's unusual. They walk up to the front door. Don't object to the hypothetical until I'm finished. So they walk up to the front door and they knock on the front door. Person answers, they say, everything okay here? Your door's swinging a little bit. And the person says yes, and they go on their way. The officer goes on their way. They meet an older person taking a walk. They know this is a community that has senior facilities, and the person looks a little confused, doesn't know which way they're going, perhaps a little, or goes one way, goes another. They walk up to the person. They say, is everything okay? Can I help you get someplace? What are you looking for? We would agree that's fine, right?
Absolutely.
That's kind of a caretaking role for that officer, right?
Absolutely.
Now, I assume the same types of concerns, but now that woman or that incident with the house is happening in something that's going down the road at 30 miles an hour. And is there a way, and I know this implicates different Fourth Amendment concerns, but is there a way that we can apply that same caretaking function that we would like to encourage to that situation where you have a moving vehicle? And if we're going to do that, what would the standard be?
I think you have to be able to articulate specific facts which lead you to believe that there is a exigency or a public safety concern that indicates. In this particular case, if when the car door swung open, if they heard the individual in the car say, "Help," or they saw the person try to exit the vehicle, then there's that, I think you would have a public safety exception. But here, all you see is a door open and close, nothing else. The
Well,
police
it's
officer-
not nothing else, because the vehicle's moving at the time the door opens and closes. I think it was going 30 miles an hour, 25
No,
miles
Your
an
Honor,
hour?
it was going 20 miles an hour if you look at the reopened suppression hearing, which is below the speed limit. And it was a
I'm not suggesting that there was speeding, but it seems to me, subjectively, that's an exceedingly unusual thing to see. A door open on a car that's moving down the road.
I think I disagree with you wholeheartedly on that. There are
You see that a lot?
Absolutely, Your Honor. It's the car, the little light on the car says car door is not closed properly. People open and close it immediately. I mean, if it had swung open all the way and was open for a while and then was closed, but that's not the situation.
If that was the impetus for opening the door, would that not fall under the community caretaking exception? Hey, is everything okay? What's going on? I saw your door open and close.
Again, if what you had here was when they stopped the car, if that was the question, but that's not the question that was asked.
So
here.
because he asked for license and registration and didn't start with, is everything okay, that sort of, you lose the ballgame on that?
If the idea was that the purpose of the stop was to see if somebody was in distress, the question should have been, is everybody okay? Does somebody need assistance? Not, can I see your license and registration, and where are you going?
If the door opened and closed a second time, would that be enough?
I don't believe so, Your Honor, unless you saw the person attempting to exit the vehicle or saying something.
Would you not agree, though, if it's happening more than once, that there may be an indication that there is a problem? Could be a child that shouldn't be in the front seat, for instance, or that a child is opening the door, but you can't tell because of the way the vehicle is.
Here, the individual couldn't even tell if it was a man or woman.
But my question to you, if it happens more than once, so opening, closing, even if it happens repeatedly, you're saying still not enough?
Okay, repeatedly is different than once or twice. I think if it's repeatedly
So how
opening
many
and closing-
times does it have to open?
I'm not sure that there's a particular answer, but I think it would have to be multiple times. That would seem to indicate, if you're opening and closing it, that there may be a defect in the door, and that would be something different, as opposed to here where it's a singular event that is momentary in nature.
Can I ask you, does what is happening with the car matter? In other words, if you look at Livingston, right, my recollection is the car there was stopped. And in Katy, I think the car had been impounded, so it was already under police control.
That's correct.
Right? Here we have a moving vehicle. Is there anything different with regard to how we might think about either the exigency or the degree of intrusion? Are those relevant to deciding how far, however we might formulate the rationale, exigency, community caretaking would stretch?
I think that what we're talking about here is that this would be an end run around Hinshaw, because this would be a simple way to say, oh, I was
Right,
raising it.
but if you had, for example, a car in an impound lot as you do in Katy, would you have the same objection that you do now? You wouldn't have, I think, quite the same concern about an end run around Hinshaw, I don't believe.
Right, because in those cases, this court has looked at things like in Tardy where the car is already stopped. A difference between a car that was stopped voluntarily by an individual as opposed to one that was stopped by the police. In this case, it's the police are stopping the car. So I do think there is a significant difference if the car is already stopped, because those are the type of situations the police come upon. A car is stopped alongside the road.
And is that because of concerns about pretext, or is it because you think that it would be less likely? You know, if you have a disabled car on the side of the road, it seems to me there's a pretty obvious argument that that could be a risk either to the folks in the car or to the people who are driving down the highway, right?
Absolutely.
So is that less so for a moving vehicle? I assume, for example, if you saw a car driving down the road and smoke was pouring out of the back, that would I would think, qualify.
Yes. And I think also that there are also motor vehicle laws that indicate that that type of smoke come out is a traffic violation as well, that it's a violation of the motor vehicle law. So, but going back to, it is the danger of pretext here. If you look at this.
Okay, but I'm just going to take you somewhere else.
Okay.
It strikes me, we've already said, what has gone here is subject to a reasonableness standard. I
Yes.
understood your argument to be, it was not objectively reasonable to stop that car simply because the door swung open and closed.
That's absolutely correct, Your Honor.
All
That
right.
is the
You've been
position
asked
we're
multiple
taking.
questions about why that's the case. And I understand your answers to that. Once the car is stopped, is there anything else to suggest that the officer was not so interested or not so concerned about whether or not someone was merely in distress that's unrelated to law enforcement?
When you look at what the interaction between the officer and my client, as well as the failure to call the other officer who was interacting with the passengers, we don't know what was said between those individuals. Did that officer ask if those passengers needed assistance? We don't know. The people didn't put that witness on. And when you look at it was very simple. Is everyone okay? If that was the reason, and if you look at the paperwork that was created by this officer in the aftermath of this, there is no mention of any of this. All it is this was a proper traffic stop, does not mention the opening and closing of the car door, does not mention that there was any public safety concern. So contemporaneous to the stop here, nothing that the police officer indicated in writing was that this was a public safety
Counsel,
concern.
just to go back to your reasonableness standard, is that a different standard than Hinshaw? What's reasonable mean here?
I
Is
think
reasonable be Livingston, or is reasonable something else?
I think it's specific articulable facts that a reasonable person could conclude that there was a public safety concern in this situation.
So, and that's the end of it. The exception is based only on the caretaking role, and there can be no criminal intent or subjective criminal reason for the police officer to make this stop.
That would be the standard that we would ask this court
That's what
to
you're
create.
at. Okay, so can I just ask just
Sure.
one quick hypo? If, let's suppose a police officer is driving down the road and sees a driver vomiting out the side of his driver's side window, and he's behind him, alerts, pulls him over, and says, A, I don't know if he's okay, he looks sick, you know, obviously, obvious indications that something's not well, and B, he might be a drunk driver, and I'm gonna,
I think that's a different standard that you're talking about. There are a number of cases from other jurisdictions that indicate a vomiting passenger isn't sufficient to establish it reasonable. But in your case, you would have an individual, if they're vomiting out the window, then the person isn't paying attention to what's happening.
but I'm saying under your exception, if that testimony was given at a hearing, would the fact that the officer said, I also suspected drunk driving, is that stop no longer good?
It would have to articulate more as to why, other than just merely vomiting, I don't think would be an indication that the person was intoxicated. Usually the stops for intoxication would be some type of action by the car, either it be swerving, going too fast, going too slow, the way that it was being driven. Merely vomiting could be, you know, the person ate something bad at Taco Bell.
But I think the judge's question goes more towards, assume they don't have what you would normally have to pull over a car for suspicion of drunk driving, but you have a legitimate concern the person's health, there might be a health issue. Is the fact that you also suspect drunk driving negate the community service aspect of the stop? I think that's what that hypothesis.
Well, I think it goes back to the idea is that is this going to be used as a pretext to get around Hinshaw? And what I see in this particular case...
Well, I think your point, I think where you've been trying to go with this, it's not so clear in the briefing, that at the end of the day, this is really just about the exclusionary rule.
That is
There's
correct.
absolutely no reason any cop cannot approach anyone if they think someone is sick, vomiting, whatever it is. Nothing stops them from doing that. It may indeed be within what they understand is their duty and obligation as a police officer. The only question is whether or not, if they discover anything during that stop, it can be admitted at trial.
So let me
That is
rephrase my
Okay.
question. If you have someone who's pulling over and they suspect they might be ill, and they also in the back of their mind think because they're acting this way, they may be drunk driving, but they don't have enough for a stop on drunk driving, would that be suppressed? Is the dual motive then demand, I guess, suppression is what we're
I
talking
think you need
about.
to have some type, it has to be articulated in a way that indicates that wasn't just a pretext. The danger that the position that people are taking is it would allow police officers to post hoc add a public safety exception to get around the fact that the stop did not meet
But you'd
the standard
still
in
need,
Henshaw.
under Livingston, articulable basis for doing a community safety stop.
That's correct, Your Honor.
But you may have, so in my hypothetical, you have that, assume you have that based on, but in the back of your mind, you have another reason for this, maybe criminal.
We would say that it should be independent, and that's the position that we are asking this court to. I understand the position that Your Honor is
Independent,
taking.
I understand, I'm not trying to give you a hard time, but independent to me can mean two different kinds of things. Independent can mean, I do have this reason, which is a good reason. There may be other reasons too, but this independent reason is enough, or independent in thought. I don't have this other thought. Which is it?
I think it has to be that the purpose of it, otherwise what you are going to create here are two distinct standards. One which you have done in Henshaw and Tardy based upon Katie as to what you can do in terms of an impounded car that is already stopped. And that
But
would
we're
be
beyond that somewhat. I mean, one argument you have, I think, if you're still pressing it, is Henshaw limits this and excludes this type of analysis. But assume there is your position that independent means an articulable independent basis, or independent means independent in thinking?
I think it has to be the former, not the latter. That's the position that you are taking.
Independent in basis?
In basis.
Okay.
Well, I'm sorry, your red light is on, if the
Okay.
Chief Judge will permit. It does seem that if that's your standard, any officer who really is interested in pretext, not genuinely trying to do their job, can easily get around that by simply never mentioning the law enforcement motivation.
That would be correct, Your Honor, but that's not what happened here.
No, I understand that, but I'm just saying with respect to the standard, it seems to me that it's a little bit difficult, the way you're trying to craft this rule, if your concern is about pretext. I'm not sure if that's what you hope the rule will achieve, I'm not sure that it does that. That's what I'm saying.
If the officer had not also stated that he believed something illegal was going on, then this would be clearly just a community caretaking exception.
Well,
And
if we recognize as such, let's put that one to the side for one moment. I mean, the point is, we have said the stops have to be reasonable. I mean, when an officer is not wearing their law enforcement hat, that is what the board says, reasonable conduct by an officer.
Right.
So whether or not a door swinging open once, when he's not speeding and he's not veering off the road is reasonable, it strikes me as the only question before us.
I think that we would prevail under, and the position we've taken in our briefs, that we would prevail under either position. And we absolutely believe that this was not a reasonable belief that this was a public safety issue. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court. Saad Siddiqui on behalf of the Bronx County District Attorney's Office and the Office of Darcel Clark. The appellate term properly found that the stop of defendant's car was justified based on considerations of public safety, and this safety concern outweighed the interference of defendant's liberty.
Okay, so that sounds right, that if there's a public safety concern, that an officer should be able to act in a manner that's reasonable. Why was it reasonable here to stop the car?
Well, Your Honor,
Based on a door swinging open and closed?
well, it's not as simple as just a door open and closing. The
Oh, what?
testim-
Oh, I'm sorry, then I missed the record. What else
Well,
was there?
The record made it very clear. This was at night. This was 8:35 p.m., May 5th, 2017.
Yes.
Officer Haskovic, a 5-year veteran of the NYPD, was just surveilling in an unmarked police cruiser.
Mm-hmm.
Here's what he observed. He observed the car traveling 25 miles an hour, not 20. That was the finding by the appellate term, which has substantial support in the record.
Which is not excessive, right? It's
No,
not above the speed limit.
It's not above the speed limit, but certainly.
So he's
20
complying with the law?
He's complying with the law. The officer also testified that there was one car in front of defendant's vehicle. Additionally, that there was traffic on the road at that time, and that, in general, this is a busy area, busy intersection. And the officer testified very clearly that the car door opened and closed. It was, in fact, He testified it abruptly opened and forcefully closed.
Well, what does abruptly mean there?
Certainly that it was unexpected. It happened
Well,
out of
okay,
nowhere.
but it's pretty unexpected that that happens, right?
Yes.
So I'm not sure abruptly adds anything.
But it does go to Your Honor, I would submit that it goes to the fact that this doesn't happen all that often.
Well, can you tell me you've never opened a car door in a moving car?
Certainly,
yourself?
Your Honor. But
You never have?
No, I have opened.
Okay.
But I would say there's a difference here.
Was it abrupt when you did that?
Well, generally, when the car is moving and you try and open a
All
car
right.
door to
Go
unfasten
ahead.
the seatbelt, you are dealing with other factors which you can reasonably infer.
Have you ever had like a coat belt stuck in a car door or a seat belt stuck in a car door? You didn't notice it until you were driving and you opened the door and closed it, pulled the thing in?
Yes, but Judge, in that situation also, there's only so far I could open the car door. When you're moving a car, you are dealing with issues like wind resistance, friction. So to the extent that the car door was going to open, it's going to be minimal. Here in this
You ever seen
situation,
anybody in a moving car open the door and throw something out, like litter or something, or spit out of the side of the door and then close it?
generally not when the car is moving at 25 miles an hour.
Okay.
And in this instance, what Officer Haskovic observed was that the car, which was one car length in front of him, he's sitting in the driver's position of the unmarked police cruiser. He sees the front passenger side door open. And it clearly opened with enough force and far enough for him to see it in his line of sight.
Does he see anything going on inside of the car that indicates distress by someone?
No, he does not. The testimony is clear, he didn't hear anything and he couldn't peer into
Does
the
he
vehicle.
describe erratic driving while this door is opening and closing?
No, he does not. No, he did not describe that. That wasn't here.
So it opens and it closes again.
Yes,
That's it.
but that's enough.
And
Counsel,
when he
I-
tried to pull over, the car pulled over, right? When he-
That is correct.
it didn't in any way try to evade the officer.
Not at all. But he pulled the car over out of concern for the welfare of the passenger. The
So
officer,
why didn't he then go to the passenger side first?
well, he had a partner. His partner went to the passenger side and he went to the driver's side. And at that moment in time, when he interacted with the defendant, there was the odor of marijuana. And at that moment, the stop transformed. It was no longer a community caretaking role. The officer was acting in his capacity of law enforcement. He had probable cause.
So how do we address, or perhaps you don't think it's an issue, the pretext concern that counsel raises? That has also been noted in the case law.
Well, I would go back again to the standard that this court opined in Robinson, that as long as there is an objective, reasonable, articulable basis, again, the standard has always been one of reasonableness. And here, in this instance, we had an officer who was very candid in what he observed.
Counsel, but I think the problem with using Robinson seems to me to get at the pretext issue is, as I remember Robinson and Wren, it's you have a violation, you have a probable cause, let's say, for a traffic violation, but in your mind, you think it's something else, right? You think it's some other criminal activity. And the issue in Wren and Robinson was, if you really have the traffic violation, which gives you probable cause, let's say, to pull the person over, can you, in the back of your mind, be doing that for another reason? But there was no question that the stop itself was lawful. It was. The question was motivation, purely motivation to say, can I use a violation to investigate a different thing? This, it seems to me, is somewhat different because the initial stop itself is not based on any probable cause. It's based on something else. So we're giving an exception for something, right? And thinking, are you using that exception, which doesn't require you to see a crime or have reasonable suspicion of a crime under one version, but you're using that because you have less than reasonable suspicion to investigate a crime? So it's a little bit different of a concern, it seems to me, than Robinson and Wren.
Your Honor, it is different, but the similarity, at least in the analysis in Robinson, rests with the subjective intent of the officer. This court has always looked to objective standards, objective, reasonable, articulable facts. Notwithstanding the fact that this officer may have had a law enforcement concern, he still had an objective.
The fear is you're getting around the Fourth Amendment by using something that allows you not to comply with those strictures. And what you're really doing is doing it for purposes that would implicate the Fourth Amendment, which is different to me than Wren and Robinson.
But in this case, you had an officer that acted out of a public safety concern. Specifically, he was acting out of the concern for the well-being of that passenger sitting in the front seat.
Can I ask you about the community caretaking exception you're proposing? So you reference Livingston at some length, right?
Yes.
There's a decision from the U.S. Supreme Court from a couple years ago. I don't think it's cited in the briefs, and I don't know if you happen to have read it. It's called Caniglia, and it's a case about how Katie applies in the context of a home. And the First Circuit there had said, we're going to invoke the community caretaking exception. And as I read the Supreme Court's opinion from a few years ago, it expresses some real skepticism about the breadth of that exception. And in fact, there's a separate writing which says there's no overarching such exception. You might want to look at exigency, but there's not a community caretaking exception in some broader sense of the term. I don't know if you happen to have read that case, but do we need to adopt this distinct exception that you're proposing, or can we look at this in terms of exigency? And if so, where does that lead us?
Well, I would say that this exception, specific to the community caretaking function of the police, has been adopted in other jurisdictions, and the exception that has been created in other jurisdictions, because both my adversary...
Although I'm not sure that those jurisdictions, so Livingston, for example, is from 2017.
Yes.
And this decision from the U.S. Supreme Court is more recent. It's from 2021. So I'm not sure that the jurisdictions that have adopted the exception have had a chance to think about how the Supreme Court's articulation of those Fourth Amendment principles might map on to the community caretaking exception. So if there is some question that the Supreme Court has raised about that, where would we be if we thought about this in terms of exigency?
Well, we would be, in the rule that we are proposing, it specifically deals with the fact that the intrusion of the police in observing an objectively reasonable, articulable public safety concern is tailored to rendering assistance or mitigating
But it
that
doesn't
harm.
need to be urgent in any way? Exigency, I think, usually conveys some sense of urgency.
Well, certainly, that you should be able to do it at that time, and that's what happened here. He saw the car door open and close, and Officer Haskovic effectuated the traffic stop.
Well, why not, if you were concerned, why not just follow the car for a bit? And to some of the earlier question, what happens if it happens again?
Well, in this instance,
The stop is intrusive. Would you agree with that?
yes, but but the intrusion was minimal. It was
Stopping the car is a minimal intrusion?
in relation to what the officer was trying to do. He was trying to ascertain whether or not the front passenger, needed assistance.
Right, and so I guess my question is, couldn't you do that in a less intrusive way by following the car for a bit?
Well, he testified he also couldn't see inside the car. He
You could
didn't know.
see if the door opened and closed again, right?
Yes, but he couldn't know. He
Or
was
if
not
the
able
car
to see.
veered off, or sounds emanated from the car.
Well, he testified he didn't hear anything.
But that's what I think is being
Certainly.
suggested. Perhaps a little bit more time would have gotten the officer past the line of, maybe everything's okay, maybe it's not, to this looks like I should really stop this car.
But when we're talking about public safety, a few seconds can make
But
all the
what
difference in the
was
world.
it about the opening and closing at 25 miles an hour, that one opening and closing, that made it such that that car needed to be immediately pulled over instead of doing as my colleagues are asking?
Well, in this instance, the officer testified. It was the fact that it was just out of the ordinary. It's not something you see every day.
If we disagree with that is not an objectively reasonable conclusion to come to. It's already been suggestions, and you've admitted yourself, you've conceded, that one might open a door of a moving car, moving at less than the speed limit in a city speed limit. I'm not talking about the highway at 65 miles an hour, right? That might have objectively reasonable, innocent reasons why you would do that, perhaps to actually ensure the safety of the rider. If your seatbelt is stuck, you want to put that seatbelt on. Or if the door is unlocked, you want to make sure that door is locked. So there may be reasons to open and close a door that actually ensure safety rather than put someone at risk
But what was relevant here also was the fact that it was.
All I'm saying is if we disagree and say that it's not reasonably objectively reasonable, excuse me, based on the facts here and what the officer articulated as reasons for the stop, that for us to say that that was reasonable under circumstances in pursuance of the public safety, do you lose? I mean, aren't we done if we
Well,
disagree at that point?
But we would still ask that the court adopt our analysis in the framework as the rule of law with respect to how to approach these.
But I'm saying,
kinds of-
doesn't it all turn on the conclusion of whether or not it's objectively
Yes, I would-
reasonable?
yes, I would
That
consider
opening
that,
and
yes.
closing really does raise a concern about public safety.
But-
Just what you saw in that moment.
But as I indicated, Your Honor, it goes just simply beyond the mere opening and closing. There were other factors, there were other observations.
That's what you started your argument with, Counselor. You mentioned that it was 8:30 at night, that it was a busy street. I think you said something about going 25 miles an hour. I was very curious, so I'm glad you raised it again. Where was that all going? Because other than a door opening on a car, none of that strikes me as exigent or amenable to a community caretaking purpose. So what was your point?
His
And the
concern-
officer didn't give those reasons.
Well, he did. He
I thought he said it's because the door opened and closed, and that was unusual.
But he also
He didn't say it was
testified-
8:30 at night on May 17th, when I think it's still daylight.
At 8:35 at night on May 17th, it was in fact dark, and he testified to that. The testimony was clear. The sun had already set.
Did he say that's why I stopped?
Well,
The combination of those things?
he spoke to the totality of the entire situation.
Okay, when you say that, was he just merely saying it was on a specific date at a specific time, as opposed to that forming the basis of the action?
Your Honor, what he specifically said was that the car was traveling at 25 miles an hour. It opened, it closed.
Yes, that's what he
Yes.
said.
And he also said that there was traffic on the road, that there was traffic. That was elicited during the questioning. And
I'm clear, but it's not that which formed the basis. He didn't say. Are you saying that he said because there was traffic on the street, that there was a concern about an accident or something happening because that car's opening? I'm not seeing the connection between setting the stage or the background of here's what's going on in addition to the car driving. What I'm hearing from you is he gave a specific date, he gave a specific time, but as to the actions that led to the car being pulled over, it was because it suddenly opened and it closed, so I pulled him over.
But it's also looking at it in the context of the totality of the
That's what you're
circumstance.
asking us to do.
Exactly, that's what I'm asking,
Okay.
and that's what
If
Livingston
we
has
read the
done.
record to not indicate that he based it on the totality of circumstances you're pointing to, that it's only about the opening and closing, your argument is still that just opening and closing the door was enough.
Based on his observations, we would submit that that is enough.
And if we disagree with you,
We would,
then it's got to be reversed. You agree?
yes, but we would still ask that the court adopt our analysis. And one point that my adversary.
What do you mean by that? That we would adopt an exception based on public safety or community caretaking, and then once applied,
That once applied,
we
that
would
the-
either affirm or reverse depending on what
Yes.
facts we think are elicited?
and that
Is
exception.
that what you're asking?
Yes, Your Honor, and that exception would be based on objectively articulable, reasonable public safety concerns, that the intrusion is tailored to rendering assistance or mitigating the peril, even if the police had a subjective law enforcement concern, and that once the assistance, of course, had been provided or the peril mitigated, that the traditional Fourth Amendment analysis would be evaluated under the traditional Fourth Amendment analysis. And I would submit that the rule that my opponent, that the defendant is asking for is unworkable. Respectfully, police work is multifaceted and cannot be cabined into discrete functions. Police officers have both a law enforcement and a community caretaking role. And you can't just separate the two so easily. They can have a concomitant concern of law enforcement and also a public safety concern. The fact of the matter is, the officer may have testified that, yes, he was concerned about the illegal activity.
Well,
but
do you think that there's a car door opening, very briefly and closing, moving at 25 miles an hour, it has anything to do with the possibility of criminality?
It could certainly suggest, if you were talking about the passenger door, that you have a front passenger who's trying to get out of the car. And those were the reasons that he even articulated in his testimony. What if someone was being kidnapped? What if someone was trying to leave? He wanted to find out what was going on. That's a legitimate safety concern. And to the extent
I
that
wasn't asking about safety, I was asking about criminality.
But with respect to criminality, it goes hand in hand in that
Sufficient to stop the car? Sufficient to stop the car?
Certainly if he's got a concern that someone is in distress,
No, I guess let me try it a different way.
certainly, sir.
To stop the car, you would need to have probable cause, yes?
If we're talking about a criminal
We're talking
investigation.
purely about, let's say his testimony was, I had no community caretaking function. I thought there was criminality going on, and the basis for that is the car door open and shut. Is that sufficient legally?
For probable cause, no.
Okay.
If we're talking about the front passenger side door,
Front
yeah.
passenger side door.
Yeah, there's no probable cause. And we would concede that. If there are no further questions, Your Honors, I would rely on our brief, and we would again ask that the court affirm the appellate term's decision and the determination and hold that Officer Haskovich's stop of the defendant's vehicle was a proper exercise of the police's community caretaking duties. Thank you.
Just a couple of points, Your Honors. Going back to Judge Troutman indicating, there is a difference between Officer Haskovich's testimony at the original suppression hearing and at the reopened suppression hearing. At the reopened suppression hearing, he modifies his testimony and testifies that in point of fact, the car was only traveling at 20 miles per hour, not 25 miles per hour when the door opened and closed. And going back to Judge Wilson, that is the whole reason. That's it. The only thing that he articulated was the opening and closing of the car door was the only predicate for believing that there was a public safety issue. And as to Judge Halligan, the issue in Coniglia was whether the U.S. Supreme Court was going to extend the community caretaking exception in traffic stops to a home. And the determination of the U.S. Supreme Court was that it would not extend it to a home, but did, again, reaffirm that there is a community caretaking exception for a traffic situation.
Well, at least for, I think, either an impounded vehicle or a disabled vehicle on the side of the road. Do you read it to go further than that?
I think you can read it to go further than that, because they make I believe it was Justice Thomas who wrote it, was that they were not saying anything as it related to whether it eviscerated that deals with traffic situations and stopped vehicles. So I think there was an idea that there is a community caretaking exception for traffic stops. So we would ask Your Honors to reverse it on the basis that there was no reasonable basis to believe that it was only any public safety issue in this particular case. Thank you, Your Honors.
Thank you.